A warm welcome to our audience. Thank you so much for joining me today and our panelists. And thank you for taking the time out. I know as estate agents or property practitioners, as they now call us, you are very busy. So we are really pleased that so many of you have taken the time out to be with us today. Now, I just want to give you a background from what is currently happening out there. Somebody told me the other day that more than 60% of registered property practitioners are actually candidate property practitioners. Then we also had that in the last, say, 2, 3, even 5 years, every year there was just new laws entered into our lives, and somehow the people working with the offer to purchase got quite frustrated. So with this background, I have decided to put this webinar together and get some of the expert attorneys in the field in to give us some guidelines of how we can make real estate still simple with having an offer to purchase that will at least satisfy all the needs of everybody that will touch that document. So please allow me to welcome our panelists with me on the show this morning. First and foremost, we've got Anastasia. Anastasia, you can just wave for us there and say hello. Anastasia is a practicing attorney and conveyancer, and she's at the Ilovo office of STBB. She's been in the field for many years. She's one of the senior conveyancers, and she has made a name for herself with public speaking, and she is no new face to the arena of real estate. And then we've got Johan de Plooy with us. Johan has got his own business, and he's been in the field for about 20 years. He's done a lot of bond registrations, conveyancing, and also developments. Then we've got Marius van Rensburg. I have met Marius some 20 years ago. Marius is also a conveyancing attorney with Schindler's Attorneys. And I remember, Marius, you have written a very nice handbook for estate agents, and I guess that you've had to make some changes recently, quite often.
I have.
So with that background, and obviously you all know that I'm in heart and soul a real estate agent or a property practitioner, so I come from the other end of the spectrum, and daily we interact with estate agents, principals, and I understand the frustration, hence the fact that we are putting this together for you this morning. So without further ado, and I do hope that everyone is now into our virtual town hall. So I'm going to start with our first question, and I'm going to address that to Johan de Plooy. You know, one of the things that I think to give us insight into the contract, the offer to purchase is actually a tool in the bag of the estate agent. But it's so important, and I think for every new property practitioner starting today or started yesterday, that they understand this journey of the offer to purchase, you know, where it originates and where it finally ends up. So Johan, can you take us through this offer to purchase, where it starts, and the journey that it's followed, showing us who will handle that document? Johan.
Thank you, Linda. Thank you for the opportunity. Yes, the offer to purchase, often called the deed of sale or sale agreement, I think actually flows through a lot of hands and entities and people, and I think it's very important for the estate agent and the estate agency to understand that this is a very important document. The agreement will firstly be used within the estate agency itself. Inside, there's a lot of legal and ethical requirements set out in the Property Practitioners Act in how and where the sale agreement must be attended to within the estate agency business, especially now with the Papaya Act, which Marius and Anastasia will talk about a little bit later. Then obviously the first person to use the agreement within the agency will be the administrative staff, who will scrutinize the agreement and ensure that the agreement is correctly completed. And then the agreement will be sent to the principal, or the principal will sign off the agreement. We obviously also know that if a candidate property practitioner may not sign the agreement just by himself, they must always be attended by a full status property practitioner, and obviously then the principal must scrutinize and sign off the agreement. The buyer and the seller are also the most important parties of the sale agreement. I often see that either the buyer and the seller send this sale agreement to the attorneys and or advocates to be scrutinized and to basically look into the rights and responsibilities of the agreement. So it is very important that the agreement is completed correctly and concisely by the estate agent. Then the agreement will be sent often to the mortgage originators. The mortgage originators will then obtain finance for the buyer and send the agreement often to different banks, or the buyer may send the agreement directly to the financial institutions to obtain finance. I often find that complex agreements, i.e. development agreements or commercial agreements, must be completed very carefully and very concisely for the banks to approve the loan for the buyer. And then the banks may ask questions on these sale agreements, and I often find that if the purchase price or the payment of the purchase price is not completed correctly, the banks will often then ask questions regarding this agreement. So it's very important for this agreement to be completed correctly. And then the agreement goes to the transferring attorney, the most important person in the whole value chain. As we know, the transferring attorney needs to do the transfer and attend to the transfer from and transfer the property from the seller to the buyer. And what we often found as transferring attorneys is that when the agreement is not correctly completed by the buyer or the seller, and terms are not clear and concise, there might be questions from the buyer and the seller later on, and even maybe lead to, let's call it, disputes and or court cases. The sale agreement will then be often sent to the bond attorney. The bond attorney must ensure that the sale amount, or let's call it the bond amount, agrees with the sale agreements and the bond instruction that he received from the bank. It's important that those clauses are completed correctly. And then the agreement sent to SARS. The transferring attorney loads the agreement on his computer system and sends it to SARS to obtain a transfer duty receipt. If there's any questions in from SARS and the agreement is not, again, correctly completed, SARS may ask a lot of questions, ask for supporting documents, and then it may also delay the transaction. The agreement's often used as an invoice. I often say to clients that remember, a sale agreement, a property sale agreement, acts as a statement and invoice later on in your life. It can be used for VAT purposes, income tax purposes, capital gains tax purposes, if you need to calculate capital gains tax in the future. So it's a very important document to keep also and to safekeep for both the buyer, the seller, and the estate agent. And last but not least, if there's a dispute between the buyer and the seller, the agreement will act as the main document in court. And obviously there will be witnesses testifying to agreement, who signed the agreement, when was the agreement signed, how was it signed, who witnessed the agreement, and none of us really want to be in court. We want to make transfers happen, and obviously transfer the property from a seller to a buyer. Yeah, that's from my side, Linda.
Well, Johan, I think it is correct to say that that document must be seen as a potential court case. Now, I just, from working in the industry over so many years, what I've realized when you practice in the luxury market, this is where people do have the money to easily sue either the estate agent or the other party. So you might operate in the lower end of the market and think you get away with documents that are not properly completed. But I can promise you, once you enter the luxury market, you're in for a surprise. So then it becomes really, really important to ensure that the estate agent completes the document 100%. Now, very interesting, Johan, about what you said. I can just, when you mentioned SARS and the credit manager at the bank, those are the guys that we should be scared of, because if you know them, then you know how difficult they can be. But it is so important to understand, and thank you for sharing that with us, that route that this document will travel. So Anastasia, I'm going to address the next question to you. Now, keeping this in mind, this complex route that this document will travel, from your experience, I want you to just share some ideas, maybe from what various companies are doing to simplify documents, because we've got to keep in mind that quite a high percentage of our estate agents are candidate estate agents. So just share from your experience what companies do to simplify the contracts for the estate agents.
Thank you, Linda. Thank you for the opportunity to join you today. So firstly, I want to say that I fully understand that the buying and the selling of a property is very stressful, not just for the seller and the buyer, but for all the role players in the transaction, including the property practitioner and the conveyancer. I also understand that for many people, the sale and the purchase of a property is probably the biggest transaction of their lives. And that is why the role that the property practitioner plays is so vital, because it is the property practitioner that holds their hands when they conclude that sale agreement and facilitates the conclusion of that sale agreement. I want to start by chatting about what is important and non-negotiables with regards to that document. Firstly, in terms of Section 2 of the Alienation of Land Act, a sale agreement, a sale of an immovable property, must be in writing, and it must be signed by the seller and the buyer, and it must be witnessed. I'd like to make mention of that. With respect, we often receive agreements that have not been properly witnessed. You then have certain conditions contained in that agreement, and they are non-negotiables. We call them the essentialia. Those are the essential conditions in the agreement. And the three essentialia are: who is the buyer? Who is the seller? What is the property that is being sold? And what is the purchase price for that property? You then have other material conditions that you build into your contract. And you were right in the beginning when you addressed the question to me, when you said it's complex. It's not just complex for the seller and the buyer, but it is also complex for the property practitioner that needs to go through that agreement with the seller and the buyer. Because what is very important, and for every property practitioner to understand, is that there needs to be a meeting of the minds. There needs to be absolute consensus between the seller and the buyer regarding every single condition in that agreement. And that consensus and meeting of the minds and understanding of what their obligations are and their duties are in terms of every condition in that agreement, that needs to be obtained and be clear in everybody's minds right in the beginning. not during the transaction or negotiated later in the transaction. And I've drafted many agreements in my life, and I've seen many sale agreements from so many estate agencies. And what I find is, and what I hear from the estate agents that I speak to, is that when they sit with the sellers and the buyers, it's not always easy to go through every single condition. You're sometimes working with captains of industry who have done this before and don't want to indulge going through every condition. And the estate agent needs to keep that together. So for it to be concise and for it to be simple, as long as all the conditions that need to be in there are contained in that agreement, is very, very important. And I'd therefore like to use this opportunity today to speak to the property practitioners and their principals and their estate agents and encourage them to look at their agreements, to review their agreements regularly. We are here as conveyancers to assist you in that regard. We'd love to assist you in reviewing your agreements, to make it easier for you, firstly, to be able to sit with your sellers and buyers and to go through those agreements. So what I found in comparing certain, estate agents' agreements to each other is that there are some agencies that compile a separate database of documentation and annexures, which the agent, the property practitioner, can refer to when applicable to that specific matter. We need to understand that all matters are unique and all of them are different. And examples that I can give you is some estate agencies will in their database have an annexure for a lower bond if the buyer were to receive a lower bond, and what happens in that instance. We also need to recognize that you do not always appoint an attorney that is on your panel. You work with attorneys that you don't always know, and you're not always sure whether you're going to draft the addendums or whether the attorneys are going to draft the addendums. So I encourage you to have those specific annexures and addendums in your database and to train your property practitioners in that regard. Another good one is the subject to sale annexure. There are so many different scenarios that can apply. The purchaser's offer is subject to the sale of their property. Has their property been sold? And if it has been sold, have the suspensive conditions been fulfilled? Or if it has been sold, has it been successfully registered? Or has it not been sold? I've also then found what some estate agencies do is they compile in their database sellers and buyers checklists and FICA checklists. With respect, it's usually your back pages that refer to the contact details and the information for the seller and the buyer. They're not always properly completed. I understand that it is difficult to do so, but I have found that if you have separate documents in that regard and you get specific training in that regard, then you refer to them at the appropriate time so that you can ensure that you properly FICA your clients, you know who your seller and buyer is, as that's the essentialia in your contract. So yes, I would encourage principals to regularly look at their contracts and find ways to simplify their contracts if possible and if necessary to make it easier for that property practitioner to conclude the deal.
Thank you, Anastasia. You've mentioned, and in practice, that is so true, that your client actually, they want the estate agent to explain what is in that contract. And most agents, if we're really honest with ourselves, don't go through every clause and explain that. That will take you quite a long time. So as an estate agent, I believe you've got to summarize it and tell the client in a summary what is, and most important, it is what is your obligation in terms of that contract. So if you're a buyer, your obligation is to pay. And I've asked so many estate agents, do you know what the obligation of the buyer is? And they stare me with black eyes. So the main thing is, if we look at what is the obligation of the purchaser, and that is to pay, I want us to just stand still on that for a moment in terms of the contract. And Marius, I'm going to address that question to you. How can we simplify our contract in focusing on the obligation of the buyer, and just share with us what should be in the contract, the essential elements that should be in the contract when it comes to the obligation of that payment.
Thanks, Linda, and thanks for the opportunity. Yeah, if I can start by saying, these contracts look, and people think it's easy to complete an after purchase, and people think it's an easy, simple process. But I know from experience that it's actually a very daunting process. And we're looking for absolute clarity. We're looking for certainty, and we're looking to keep it as absolutely simple as possible. And I can just encourage the agents and the principals, when you're completing after purchase, and particularly this purchase price clause, which is a very important clause, if you have a sort of standard simple type of scenario where there's a purchase price, a deposit, and the balance of the purchase price, but you look at various other scenarios which tend to complicate the issue. Sometimes people want to pay deposits in various installments, as an example. I really encourage you to speak to your principals, speak to the attorneys. I'll speak for Johanna and Anastasia, and I'll say that we are always available to help you guys with these little complexities. So please seek advice if there's any kind of doubt. The purchase price clause, the obligation to pay, is absolutely essential, because our job as conveyancers is to transfer the property for the purchase of the seller, but we need to collect that purchase price. And bearing in mind that collecting the purchase price also involves securing you for your commission, ultimately in this transaction. So there's simple clauses, there's complicated clauses. My personal preference is a simple clause, which is the purchase price is 2 million rand. There's a deposit of 500,000 rand. I like my third clause to simply say the balance of the purchase price is 1.5 million rand to be secured by guarantees acceptable to the seller, to be delivered within X amount of days after signature of the agreement or fulfillment of suspension of conditions, whichever is the later, and if it's a cash, to be deposited within the same time frame. If I can just pause on some of those elements, first of all, the purchase price clause. Remember, this is the culmination of you listing the property, finding your buyer, agreeing. Other parties agree on this purchase price. So this is an end point for you in terms of an agent, because this is the point where you're now going to sign the agreement. Please, I don't want to spend any time on that, but my standard clause has a little tick box system that says, is the seller a VAT vendor or is the seller not a VAT vendor? And there's so many rules around this, and it's such a complicated issue that if the seller is not a VAT vendor, it's a transfer duty transaction. If the seller is a VAT vendor, my advice is stop, go and get advice as to the consequences of the transfer duty or VAT applicability of that transaction. As I say, I could probably talk to you for an hour on this, but I'm not going to do that because it's a complicated issue. What I try and teach agents, especially candidate agents, is just stop and ask the right questions, because it really, really is very important. Then with regards to the deposit, I know you guys want to get the deposit in as soon as possible. So there's just one or two comments I have here. First of all, make sure that your buyer can actually pay the deposit. So if you're going to say the deposit's paid within 5 days, make sure that deposit's not held in a 30-day, 2-day call account somewhere. Because we sometimes have cases where buyers, we call the deposit and they say, no, it's a 32-day call account. And, there's a trust issue that falls away when the deposit's not paid in. That there's a glue that holds this transaction together, right? So deposits are fantastic. And even if it's a small deposit, I would get a deposit in. I would always try and get a deposit in, even if it's 10,000 rand. But when the deposit doesn't come in, there's a confidence issue between the buyer and the seller that tends to fall away. So try and make sure that the deposit is capable of being paid. And the second issue is, I think, make sure the deposit comes in. I personally prefer about 5 days, because when we collect the deposit, we were very careful with money. I mean, as you know, there's a lot of fraudulent issues happening. We want to make sure that we have enough time to confirm our banking details to make sure the deposit comes into the correct account. There's lots of fraudsters and they have all kinds of tricks. So if you have a deposit payable within 24 hours, is sometimes hard to collect. So, for example, what we do at Schindler's is we collect 100 Rand deposit first. And once they hit our account, we then get the balance of the funds. And that's for our protection and the client's protection, right? In regard to the balance of the purchase price, the balance of the, I personally, I sometimes see clauses that have 4 or 5 different options as to where this money is coming from. Me personally, I prefer the simple route. Purchase price, deposit, balance of the purchase price is X. Now that balance of the purchase price could be cash and it could be a bond. So just make sure that your purchase price and your deposit and your balance, if you need to write it in, add up to your total purchase price. And then, there's an element of structuring here. So, you might have a purchase price of 2 million Rand, a deposit of 500, a bond of 1 million. Then your balance purchase price will be a bond of a million and 500,000 in additional guarantees, which is cash. So I think that's my view on this clause. As I say, it can get more complicated, and if it's more complicated, please do an addendum. Let your conveyancer check that addendum for you, and let the conveyancer write it in. Maybe one last point, which is a bit more complicated. I like to try and structure deals, and I'll give you an example. I did a deal a couple of years ago, which is about 4 million Rand. The entire purchase price was payable within 10 days of the date of sale, but transfer was to take place within 3 months. And you need to understand that when we're going to secure guarantees, you can't leave your money in an investment account. Your money can't be in Allen Gray. Your money must be in a banking account in order to issue the guarantee, the checking account. So in this particular case, the buyer called us and said, I'm not closing my investment account. I'm earning 11 or 12% on the money. I'm going to earn 4 or 5% in your trust account, or 5 or 6% in my bank. So what we did was, the buyer came in, signed all these documents, paid a 300,000 deposit, paid all his costs, and we allowed him to present guarantees later. Because now what that did was, it left his money invested for a longer period of time, but we still secured the deal nice and securely. So think about this deal structuring and then the effect on your buyers as well.
Thank you so much, Marius. I think there is a lot of shortcomings when it comes to qualifying that buyer. But if I may give our estate agents or property practitioners a tip today, it is that you've got to trace the money back to its origin in the bank. And I think too many of us just simplify, take the word of the buyer, I've got the money. But if you're the person that must actually go and convince the seller to accept the offer, you've got to be pretty sure of where that buyer's money is. And there's nothing wrong by asking for proof of where's your deposit held, where is that money, and like you say, is it in a 30-day or are you going to wait for it for 3 months? Where is the money? And that is very important for us when you really want to satisfy your clients afterwards.
Or, if it's a cash deal, what's quite nice to do is ask for a letter of comfort. So the client can go to their bank and get a letter that says, we're the banker, we confirm there's X amount of money held in this account. Then you know the money is there, and your deal will kind of go ahead because you know that your buyer has the money.
Yeah, the answer is really that if you've got 5 million sitting in a bank, you would want proof that your 5 million is there. So everybody has got some proof that your money is in the bank, and that's all that the estate agent needs to conclude the deal properly. So that was on the obligation of the purchaser. But let's now move to what is the obligation of the seller, and that is to deliver the property timeously and in the same condition. Now, recently, we encountered a lot of interaction where we talked and discussed, and the law was changed, and there's now a disclosure document. So, Anastasia, I'm back at your door, and let us discuss this disclosure document and how it does help to deliver the property in the condition and all the elements around that. Over to you, Anastasia.
Thanks, Linda. So what we know is that before the 1st of February, disclosure forms were merely a recommendation to be used by property practitioners in terms of the Consumer Protection Act and the Estate Agencies Affairs Board. With the promulgation of the Property Practitioners Act, and since the 1st of February, it's now mandatory that every sale agreement which has been concluded by an estate agent between a seller and buyer must have a disclosure form. And the aim of the Property Practitioners Act is obviously to ensure a healthy property market, to regulate the property practitioner, and to protect the consumer's rights. And I believe that the disclosure form is one of the best ways to do that, to protect the consumer, but also to assist the estate agent in kicking that house with their foot in front of the buyer, so that the buyer knows what they are purchasing. What we know in terms of the Act is that an estate agent may not accept a mandate from a seller unless the seller has completed that disclosure form. What we also know is that a buyer cannot submit their offer to the seller unless they've had sight of that disclosure form and they've in turn signed and completed it. What's very important, and what I mentioned previously in the previous question that I answered, is that once again, there needs to be clear consensus between the parties with regards to the disclosures that have been made and what the seller and the buyer understand with regards to that disclosure form. It is therefore quite important that the property practitioner understands that that disclosure form is read together with the sale agreement, and that cross-references may need to be made between the disclosure form and the agreement, depending on what the disclosure form looks like. The Property Practitioners Act, there is a regulated and a prescribed form in terms of the Act, and I often get the question whether estate agents need to use that specific form. You don't need to. You can brand it, you can change it, but it does have to have the minimum requirements that are on that form. So you can add tick boxes to that list if you feel it's necessary, with pleasure, but you need to have those minimum tick boxes on your form. What's also very important is that you need to note that now in terms of the Act, both the seller and the buyer have the right to undertake independent inspections. That needs to be contained in your disclosure form. And the property practitioner needs to facilitate that so that there is clear consensus between the parties. You can't just have that in your form and then they make the decision at a later stage. Remember, there needs to be consensus right in the beginning when they conclude that agreement. So you're either going to contain those special conditions in your disclosure form, or you are going to cross-reference them in your agreement so that the parties are absolutely clear. If the purchaser does want to exercise that right and undertake an independent inspection, by when? At whose cost? Is it suspensive to the sale? Or is it merely just for them to know exactly what they are buying? So it is very, very important that you follow the same principles that Johan and Marius and I have been talking about when it comes to the conclusion of the contract with regard to that disclosure form.
Thank you, Anastasia. You know, when I listen to you, you know, you can see it's like a house. You start talking about the one room, and then there's a door opening into another room, and you want to talk about that. So just on that matter, we can also talk for hours. But thank you. I'm going to leave that question there and move on to the next one. So now you've got, this is the obligation of the buyer, and this is the obligation of the seller. But we know that sometimes people don't fulfill their obligations. And that is why the next thing is the breach clause. Now, quite often, and over the years, I've realized how often agents actually cross out sections of this breach clause. Now, Marius, I'm going to address this question to you. Why is this breach clause so important? Just taking into account what we earlier said, that your document can be a potential court case. Just take us through that breach clause and the elements that are so important, which we cannot just cross out left, right, and center.
Thanks, Linda. Yeah, I mean that breach clause is really important. And what I've learned over the years is that you have a buyer, you have a seller, and they enter into the agreement and they change their mind. I mean, that's just the reality of how this market works. You think that people make up their mind to sell or make up their mind to buy, but they don't. We have many cases where people want to get out the agreement for various reasons, and buyers get irritated. And I'm always amazed at how two sets of people you're buying sort of never met each other suddenly hate each other. They never, and the parties polarize very quickly, which we try and kind of control. And the reality is that when you have a party who's not performing the obligations with the seller or the purchaser, that breach clause is very important to enforce your rights in terms of the agreement. So we have a common law concept where you can't simply cancel an agreement. You have to put someone in what we call in mora. And in mora means to give them time to rectify their breach. Now remember, and let me use the deposit clause as an example. Deposit payable within 5 days. Buyer doesn't pay the deposit within 5 days. The buyer is in breach, but now if the seller wants to action the breach, you need to write a breach letter and give the buyer a specific period of time within which to remedy the breach. So it must be properly actioned in terms of the breach clause. My suggestion, if you're going to use the breach clause, get your conveyancer to write the breach letter. There's various forms of breach clauses, which I think it's important to really follow those clauses absolutely to the T. Why shouldn't you delete this clause? Well, you mustn't delete the clause because you're robbing the big stick approach. You're robbing the party's ability to enforce the agreement. And if you don't have a breach clause, and if you don't have consequences in terms of your commission, you're allowing the parties to be able to walk away from this agreement with no consequence whatsoever. And we simply can't have that. So, if it's a deal breaker, speak to your principal, make sure that you don't delete the really important part of this clause. But also explain to your buyer and your seller that if you delete the clause, you're robbing that party of the ability to enforce the agreement, which then becomes a situation where we hope this matter is going to register and go well. In terms of the provisions of the breach clause itself, to just a few points. One, in terms of consumer protection at the agreement, the breach clause must be reciprocal. In other words, you must have a scenario where the aggrieved party can put the defaulting party in breach. The seller and the purchaser must both have this opportunity. In terms of how many days, so you find variations: 7 days, 10 days, 14 days. I personally like 10 days. 7 days is too short, I think, because I don't want to cancel the agreement. My aim in placing someone in breach is to enforce the agreement to bring the defaulting party in line. 14 days, sometimes people are frustrated if it's long. My personal preference is about 10 days. Please make sure your breach clause allows service of the breach letter via email. Nobody serves anything via facsimile anymore, and you will never get anything to the South African Post Office, so don't worry about doing it via registered mail. I like delivery by hand and delivery by email. So you have that basic clause, which is the right to place someone in breach on 10 days notice. They must rectify their breach within 10 days. Then you have a clause which deals with if the purchaser is the defaulting party, and then of course, if the purchaser is the aggrieved party. Well, if the purchaser is the aggrieved party, you place the seller in breach, no rectification, then the buyer has the right to cancel or enforce the agreement. If the seller is the aggrieved party, and here's why I think it's important: if the seller is the aggrieved party, the buyer doesn't remedy, the seller has the opportunity to 1, cancel, and 2, enforce. Those are neither good scenarios for us. Enforcement is too expensive, and we don't want to cancel because we want to go through. Please make sure that your breach clauses can be read with your commission clauses. So if I'm going to hold a deposit, cancel the agreement due to the buyer's breach, your breach clause read with your commission clause must authorize me as conveyancer to deal with the deposit in terms of A, pay you your commission. If I'm not specifically authorized in that contract, I can't pay you a commission. You must go to court and get a court order. And personally, I don't like the clauses which authorize me to pay the buyer. I prefer to hold the money in trust and let the seller establish their damages. I think rope curve clauses are very largely misunderstood in their actual application.
Marius, thank you so much. Like I've said, with each and every clause, you can see that you can have a morning seminar just on each and every clause. But to me, that breach clause is so important because, earlier, Johan explained the journey of the document. But, you also have to think who the document will protect. And the breach clause is there to protect the agent, the company, the buyer, the seller. So you cannot just eliminate that clause. And I hope that is one of the things that our audience will recognize today. Now, I'm going to share with you something that happens in real estate offices. In the last 3 years, I said that so quite often we've got to change our document because suddenly there's a new law. And then we hear from the 1st of February, there's a new law, we've got a new document. But in practice, so I'm the one that knows what it's like to be out there in the field. So the estate agent rocks up, that buyer wants to sign right now. And I look in my briefcase, and I've just got an old document. I forgot to print the latest document at the offer, and I'm now with the client, and I conclude this document, and all the new laws are not yet added to that document. So, Johan, I'm going to address this question to you. Which applicable laws should be in the contract and that we are dealing with to cover that? And then I also want to ask, let's say, for instance, you're in that position where you've got your old document and you don't want to let this buyer get away. You sign the document that was printed a year ago, and it doesn't have the new acts in. So if that act is not, or the law, whatever, is not physically in that contract, does it exist? Can it be enforced? So over to you, Johan.
Thanks, Linda. Can you hear me properly?
Yes.
Okay. Yeah, thanks, Linda. I think in the last few years, everybody in the let's call it the property industry was bombarded with a lot of new statutes that came into place and needed to be inserted into a sale agreement. Much so. When we started with this, I think I remember it was only the electrical compliance certificate that was compulsory. Now there's quite a lot of other things. I just want to tell you a little story. One of my friends phoned me about 2 weeks ago, 9 o'clock on a Sunday night, and he said to me, what is a beetle certificate? And he lives in Johannesburg, and he sold quite an expensive property in Natal, and the purchaser, it complied with the purchase price, and the property needed to be lodged into the deeds office. And he got an email from the transferring attorney stating that he needs to supply them urgently with a beetle certificate. So I laughed and I said to him, that's obviously a certificate required in terms of let's call it the coastal areas. And if it's included in the purchase agreement or the sale agreement, he'll have to comply with it. And he sent me the sale agreement, and I said to him, well, he should have firstly read the sale agreement more carefully, and secondly, his estate agents should have maybe explained to him or averted his attention to that specific clause. At the end of the day, it cost him about 50,000 Rand to obtain that beetle certificate. It was an old house, an old big house, and the deal could have been structured differently. So again, that's just an example of, let's call it a statute law that it was included into the contract that should have been explained and read better. So in terms of statutes, Linda, yes, coming back to what Marius and Anastasia is saying, all of this is about absolute consensus between the buyer and the seller, firstly, and secondly, to ensure that the buyer and the seller comply with the statutes of South Africa in selling a product, a house. And we're moving towards, I'd say, more the American and UK and Canadian laws, where it's so important when a seller sells his or her property that certain let's call it statements about their property is made, in which the condition of the property is currently in. Say what Anastasia spoke about, the mandatory disclosure form, and etc. So obviously this session is not about explaining each and every statute and law that needs to be complied with, but things that needs to be included in the sale agreement to make the sale agreement clear and concise is things like obviously the electrical compliance certificate, how it's issued and when it's issued and how much it be issued. The gas certificate. If there's obviously a gas installation in the property, there must be a proper issued gas certificate, electrical fence certificate. If a property is obviously fenced, there must be a fence certificate. Also a borehole certificate. I often get transactions where there are boreholes in the Bryanston, or let's call it the North Cliff areas. It must be issued. It must be issued. It must be part of the contract. Obviously, entomologist certificates, as we just spoke, a lot of in the coastal areas. Consumer Protection Act. If you sell a property, especially if you're a developer and you are a buyer of that property where it's a business that's selling the property, you've got certain rights as a consumer, and the Consumer Protection Act clause must basically stipulate your rights in the agreement, and you must understand the rights. Both the seller and the buyer must understand the rights. And obviously these days the Papaya Act has come into place, the protection of personal information. It's very important because the contract is obviously signed by the estate agent in the estate agency. The estate agency will often then channel that agreement to the bond originators or the transferring attorneys, and they're not allowed to do it and divulge that information of the parties if the parties didn't agree in the agreement of sale that the information may be used. So you have to have that clause in that sale agreement, the poppy, let's call it the papaya clause. And obviously, as Anastasia just said now, the property disclosure form, the mandatory property disclosure form, it's also from the 2nd of February mandatory. So make sure it's included in the agreement, make sure it's part of the agreement. And that's just, I mean, the ones that I've highlighted now. And what I can also say is that the estate agents must also explain these clauses to the buyer and the seller, and what the rights and responsibilities of both the buyer and the seller is when they explain it to them. And if it's necessary for an addendum to be done in the agreement to make it more clear and concise for the buyer and the seller, then do it. You know, don't. I think obviously the property mandatory disclosure form is an annexure. Even the Poppy Act or the Papaya document can be an annexure, just to ensure that both parties understand that specific statute and law that needs to be included in the contract. And what I also, yes, we can just talk about what will happen a bit later on, but those are the laws and statutes that, you know, the ones that's the most important. There's obviously quite a lot more laws and statutes that can be included. I'm thinking about if you buy a property from a developer, you include the NHBRC, the National Housing Building Regulation statute, where a buyer have a 5-year and a 3-year guarantee period on a house and a structure of a house. So there's a lot of other laws and statutes that can be included, and make sure it's included. And again, like Marius says, is when he spoke about the breach clause, that both parties understand it very clearly, what their rights and responsibilities are.
Thank you, Johan. So today is really to give us some tips on making our offer to purchase a document that is easier and it's more simplified. So I thought it good. One of the most popular addenda that we use in practice is the subject to addendum. And I just want Marius, if you can take us through that. Now, when I was trained many moons ago, we had a main document, and then we had like 10, or those days even 20 addenda, and our managers would say, no, go to this addendum or that addendum, and you just add this. And it's still a practice that I'm very much in favor of, because the addenda, I don't have to then try and think the clause out myself. It is covered already. I just need, as an estate agent, to add that and fill in the details. So, Marius, I thought it good to use the subject to addendum to discuss this statement. Over to you.
Sorry. Thanks, Anastasia. I absolutely agree. I think that it's far preferable to have the subject to so clauses in an addendum. And I think, having said that, it's equally important that if you're doing a subject to sale agreement, that you have the addendum, but you absolutely use the addendum. And I think that's training for the agents, especially the junior agents. You must have the addendum. You know, I, for example, sometimes see an agreement that says, this agreement is subject to the sale of the buyer's property within 60 days. But what does that mean? You know, it's got no meaning to me. If you're going to say subject to the sale of the buyer's property, well, when is it sold? Is it sold when you sign the agreement, when the suspensive conditions are fulfilled, or is it sold when it registers in the deeds office? So in addition to that, you know, you're not dealing with the particularities of continued marketing. I had a client once who came to me and he said to me, I sold the property for 1.1 million rand. I have another offer for 1.2 million rand. And good news, it's subject to the sale of the buyer's property, so we can take the offer, can't we? I took his agreement. I said, you can't. It's subject to the sale of the property, but you've got no continued marketing clause. So what one must understand is that these subject to sale clauses are very carefully crafted, and there's lots of detail in them. So you can't think for a moment that you're going to simply write this clause out of your head or get it right on the spur of the moment. It's so important to have the addendum. And I think in terms of, I don't want to go into the detail of those clauses, but for example, it might be subject to the sale of the buyer's property. The buyer's property may have been sold, but we're awaiting a bond to be granted in that property. The property may have been sold and all suspensive conditions have been fulfilled. And those create 3 different tiers of scenarios. And it's so important for agents to do it exactly in that order. When it comes to the sale agreement, I prefer to be subject to the sale of the property within a specified time period for a certain amount, or such lesser amount as the buyer may accept. You want to have that little caveat, because if it's subject to the sale of the property for R1 million and the guy accepts it 1,900, we want something to bring the clause into that. And as I've spoken about, you know, when is the property sold? There's case law on when is the property sold. And of course, then you have your continued marketing clause. You know, your continued marketing clause, I find people get quite emotional about it because there's different approaches. You know, some of the clauses say, you know, you can present a competing offer and the seller there must be a waiver of the conditions. Other clauses say, well, you must match and meet the new offer, so the higher purchase prices. There's various parameters and various ways to do it. But I think that time doesn't allow us to go into those details. Suffice to say is read your clause very carefully, understand your clause, and make sure you have it in the addendum when you do that deal, so that it's a deal that works.
Absolutely. Thank you, Marius. There's a joke that I can remember that says all the doctor's mistakes ends up in the graveyard. But I think all the mistakes of estate agents ends up in the courtrooms. So, Anastasia, when something goes wrong and an estate agent has not completed the document properly, there are sometimes consequences. And just share with us the dangers and discuss that with us so that our audience can understand the responsibility of the estate agent and the company, how important that really is.
You said that the agreement can be a potential court case. And it was Marius that said that sellers and buyers change their minds all the time. They start hating each other. In some instances, they want to kill each other. They threaten to sue each other all the time. We deal with this every day. And I find that at the moment, I'm not just a conveyancer. I'm trying to be a psychologist as well in managing them, managing their state of minds so that I can keep that deal together. Nobody wants to go to court, but they can, and they may, and they will. And inadvertently, that estate agent will find themselves part of this litigious process. If the dispute is with regard to the contract, what was written on that contract, whether there was a consensus and a meeting of the minds with regards to those conditions. So I always say to the estate agents that I work with, you have to sweat the small stuff all the time. You have to be ready. You need to prepare yourself to conclude that deal. You need to know what the essentialia, the essential terms are before you put pen to paper. Who is the seller? Who is the buyer? What is the property? What is the purchase price? And you need to follow the laws in that regard. For example, FICA. You need to sweat the small stuff when it comes to all of that. And I always encourage property practitioners to contact us, the conveyancers, right in the beginning. If there's something that you're not sure of and you are worried about, phone us. That is why we're here. We see things differently. We've been trained differently. We know what to look out for. It's our role to hold your hands as your panel attorneys, and we would prefer to assist you in concluding that agreement right in the beginning. It's very difficult to fix something that is broken later on in that transaction. It may only manifest later in that transaction, but it was broken to begin with. So I'm going to give you a few examples, simple examples. We don't have a lot of time, but of matters that I've dealt with in my office. I dealt with a deal a couple of years ago where the seller was a trust. So what we know is you need to sweat the small stuff, you need to know who your seller is, and you need to FICA your seller. We received the deal signed by one of the trustees, and we then called for the resolutions and the FICA. One of the documents that you need to obtain when you are FICAing a trust is the trust deed, in order to ascertain who the seller is, what the seller is. And there was a condition in that trust deed in terms of which, if the trust deals with immovable property, with land, and enters into a contract regarding land, both trustees must sign the agreement as the seller or the buyer, depending on what the situation is. In this instance, the trust was the seller, and we only had the signature of one of the trustees. To give you the detail in the transaction, the trustees were a husband and wife. They were married, and they were going through a bitter divorce. The husband had signed the agreement on behalf of the trust, but in terms of the trust deed, both of them had to sign. When we contacted the purchaser to fix the wife, to fix the mistake, it was at that stage where the wife refused to enter into that agreement. It was null and void. The estate agent did not get her commission. It did not go to court, but because of that one problem, the description of the seller and who is signing, a deal was not concluded. We have a current deal at the moment, and this particular estate agency works a bit differently. They only instruct the conveyancer when the bond has been granted on their transaction. That is the way they work. All estate agents work differently. You may have your opinions in this regard, but this is the process that they follow. So I received the instruction after the purchaser had received an AIP. By that stage, the purchaser had paid the deposit into the Property Practitioner's trust account. The purchaser has buyer's remorse for whatever reason and wants out of the transaction. The seller is a Mrs. And when I did my deed search, I noticed that there's a Mr. as well. And in doing my investigations, I've realized that Mr. is deceased and Mrs. is also the executor in Mr.'s estate. The sale agreement, however, in the description of the seller, only refers to Mrs. in her capacity as the half-share owner of that property, and not also in her capacity as the executor of the estate late. We could fix that, but the buyer has buyer's remorse, and the buyer has received an AIP, but has not signed off and accepted the grant. The wording in a bond clause is also so important. And once again, another law sweating the small stuff with regard to the National Credit Act, because there is now an argument between the parties whether the suspensive condition has in fact been fulfilled or not. I'm currently busy with that transaction. I don't know where it's going to go. We're trying our very best to save this deal, but I'm just highlighting what can happen if you're not very clear on the essentialia and the agreement. If I may, Linda, I'll give you another example. And this was specifically with regards to a property, and it was a court case. And what happened was a mistake. The sale agreement referred to an IRF, but what was actually being sold was a unit, a sectional title. It was a freestanding unit that formed part of the scheme. And for whatever reason, the sale agreement referred to a freehold property and not a sectional property. The purchaser, it came to the purchaser's attention at a later stage, and the purchaser was prepared to proceed with the matter on the basis that he was purchasing a sectional unit, but he wanted a reduction in the purchase price. The seller refused. The seller refused to reduce the purchase price and repudiated. So he cancelled the agreement. The purchaser then went to court. He claimed specific performance. He wanted to purchase the property. And what the court said in that matter, and I'm going to read it to you, there was no intention by the agent or the seller to misrepresent regarding what the property is, that essential element. It was merely a mistake. But as a result of the mistake, there was no consensus. We've been speaking about consensus the whole morning. There was no consensus between the seller and the buyer with regards to what was being sold and what was being bought. And therefore, the matter and the deal was invalid. The agent did not get their commission.
Anastasia, thank you so much. I think you've made the point so clear to us. Apart from the commission, let's close with this last question before I'm going to look at the questions from the audience. Johan, on that note that Anastasia finished her question there, I want to ask you, how does it reflect on the industry at large, on the brand, on the company and the estate agent in a world where the public really hates estate agents? Where does it put our image out there if we make mistakes in contracts? Johan, you're offline. Johan, we cannot hear you. Thank you.
Thank you. Sorry. Yes, thank you. I'm of the opinion that in the recent few years, estate agents must be very professional in how they conduct the signing of the sale agreement between a buyer and a seller. And I always say to the estate agents, they must prepare very concisely and do their homework before they even start with the sale agreement between a seller and a buyer. I mean, the examples that Anastasia gave now between unit and earth, etc., that could have been avoided if they did a proper deed search or asked the conveyancer to help them. And also all the laws that we spoke about and the statute that we spoke about is it's important to understand it and to explain it to obviously all the parties. And what could happen is that I know of a large estate agency that had to close down because of a court case between a buyer and a seller, and it cost the estate agency millions of rands. It cost the agent, the specific agent that dealt with them, at a lot of money, and also the estate agency. And we don't, as Anastasia said, we don't want to be in court. So it's almost like I say, my wife often says to me, do you understand what I say? And it's sort of, I think when an agent speaks to both and communicate to both the buyer and the seller to make sure that they understand firstly what they sign and how they sign it, and things that can also be said in the industry. For instance, in America, there's what they call a closing meeting. When the buyer and the seller they sign at let's call it the solicitor's office with the estate agent. I don't think in South Africa we must actually go there, but the estate agent must obviously, and again, ensure that he understands it. And then things that can go wrong, and Anastasia spoke about it, but also what I want to also emphasize is that if there's a dispute in the whole transaction, can obviously affect the estate agent's commission. Matter can go to court. There can be a reduction in the purchase price. The matter can be cancelled, and it's all costs and time. So we don't want that. Okay, thank you, Leva.
Johan, thank you. We're now going to deal with some of the questions from the audience. Quite a number of questions have come in. So I'm going to deal with the most relevant to what we've discussed this morning. So here is a question. How do we handle a disclosure form if it is a rental property? The owner knows nothing about the property. So I would take it that it's probably sometimes the owner is overseas and there was somebody renting the property. So Anastasia, can I address that one to you?
Thanks, Linda. So this question is specifically with regard to rental properties, but it applies on sale of properties as well. What we know is that the disclosure form is mandatory and it forms part of your agreements, sale or rental, non-negotiable. There are instances where particularly the owner will not want to sign it because they haven't lived in the property, they don't want to make disclosures, or they cannot sign. They've given somebody power of attorney to sign on their behalf, or there's an executor that's been appointed in an estate late. What's very important is for the agent to disclose that to the purchaser when they talk about the disclosure form, when they deal with the disclosure form. If the seller did not complete and sign that disclosure form, but somebody acting on behalf of that seller, for example, or the landlord, for example, in terms of a power of attorney, you need to show that power of attorney to the buyer and the tenant. They need to see it as part of that disclosure. And they need to be aware that it wasn't the landlord or the tenant that did it. You can only be held liable for something that you didn't do, not something that you've done. If you make all efforts as an estate agent to explain the law to your seller and buyer, landlord and tenant, and to explain their obligations to them, and despite that, they refuse to sign and complete a disclosure form, you cannot do more than that. You can't hold a gun to their heads. You need to prove, though, that you've done your job. So keep a record of what you've done, all the efforts that you've made to facilitate that. And if, for example, it is the seller who is refusing to sign that disclosure form, then that is what you disclose to your buyer. And in most instances, the seller's just making it very difficult for themselves to get a good offer, and that's how far you will go in explaining it to the seller. But you can't hold a gun to anybody's head. Try your very best to get them to comply with this statutory requirement, and make sure that if somebody is signing on their behalf, that you properly disclose that to the other party.
There's another question, and Marius, you can answer this one for us. And what happens if an owner completes a property condition report according to what the condition of the property was when they last saw it, and didn't disclose all defects purely just because they haven't been to the property in a few years? How will this impact the sale? I think it's a similar question, but maybe I've just read it as it came from the estate agent.
Yeah. Look, people raise a lot of issues around completing these disclosure documents in rental properties and sales properties, and they try and postulate that it's very difficult to complete these documents. If you look at the detail of that prescribed disclosure document, it's actually not that difficult. The questions are very broad based. If, for example, if I have a rental property or a property that I'm either renting out or I'm selling the property and there's a tenant in there and I haven't been there, the question might be, are there any electrical problems? Well, if my tenant hasn't complained about electrical problems, I don't know about electrical problems. But I think to more directly answer the question that's been asked by Alette is the seller's obligations to make a proper disclosure. If they get the disclosure document, they shouldn't guess at what the answers are. And I think that's the worst possible thing they can do. If they don't know the answer, they must rather say, I don't know the answer. It's a little bit the same as my view is, if you have a seller who lives overseas or a seller who's an executor in a state. So the executor appoints you to sell the property. Now you say to the executor, the law is that I must complete this disclosure document. The executor will say to you, I've never been there. I can't disclose this document. What I've told people to do is have an addendum. I actually write on the disclosure document, I am the seller. I am an executor in this estate. I'm sorry, Mr. Buyer, I can't make any disclosures to you whatsoever because I've never been to the house. So, and then what I do is I take that disclosure document, I annex it to the sale agreement anyway, because the law says the disclosure document must be annexed, and that's your responsibility as an agent. So I would annex the disclosure document with a note on the disclosure document signed by the executor, but saying, I can't disclose what's in this property. And I would say to the buyer, the seller can't disclose because they're an executor or they haven't seen the property. They're unable. Therefore, you, Mr. Buyer, must take more active steps yourself to inspect the property properly yourself. And if so needed, go and get a property inspection to satisfy yourself. But that's the way I approach this kind of issue.
Can I add something to that, please, Linda? Can I add something?
Yes.
Because I absolutely agree with Marius. You disclose that they cannot disclose. That is how far the property practitioner needs to go. And then the property practitioner needs to deal with a consensus. As Marius said, because you've disclosed that the seller is unable to disclose, the buyer has the right to undertake that independent inspection. As a property practitioner, you would probably recommend to the purchaser to do that independent inspection because the seller is unable to disclose. And then you need to make sure that you deal with it in the special conditions in your disclosure form or cross-reference it in your agreement.
Thank you. We cannot go through all the questions, but I'm going to just pose one last question, which is similar to the ones that we've just dealt with. But this goes a little bit further. Can an estate agent complete and sign the condition and something goes wrong? Will the estate agent be held liable later on? So Johan, can you just embroider on that? Will the estate agent be held liable if the seller does not stay true to the disclosure document?
Well, no, firstly, the estate agents must realize that they step into the shoes of the seller. And that's the job of an estate agent. Anything estate agents say or do or act on behalf of a seller can be used, like I was saying, in a court of law against the estate agent later on. Obviously, if the estate agent wasn't fraudulent, then it could count for the estate agent, but that can definitely be used in a court of law. And the questions may be asked, what did the estate agent know or did not know? In terms of the Section 67, there's a lot of questions these days about this mandatory disclosure form. And there's been no court cases about it. So it's always like when a new statute and act comes into play, it basically says the following. It says that, and the wording of the specific clause is a bit confusing to a lot of people. It says that it must be part of any property sale and transaction, or in terms of that is firstly what it says. But as Anastasia and Marius confirmed, and also correctly, is that if the seller then basically decides not to complete it, obviously would be best just to scratch it out and still include it into the sale agreement and say either not applicable, or as Marius says, the seller would not like to complete it. And then the buyer must then understand that the seller would not like to complete the specific questions in the mandatory disclosure form. It does not make the agreement void or voidable, for sure not, And if on the question, if the estate agent then completes it, he must then, I would say, stipulate that he completed as an estate agent, not as a property, say for instance, a house inspection person. If the buyer wants it, at that point in time, wants it to be, let's call it completed, but I would advise at that point in time for the estate agent not to complete it, rather than to get a professional person. And obviously Section 67 says that both the owner as well as potential buyers of the property may wish to obtain professional advice and undertake a professional inspection of the property. So a professional inspection report may, as Anastasia says, supersede or be included in that mandatory disclosure form, because it's going to be more than the required documentation or questions. And under such circumstances, adequate provisions must be contained in the agreement of sale to be concluded between the parties pertaining to the obtaining of such professional advice and of conducting the required inspections and or disclosures of the defects, making it the required warranties. It's just obviously it's a discussion on its own, just to answer that question. Remember, this obviously goes hand in hand with the foot stewards clause and how the property is sold. But coming back, I wouldn't advise that specific agent to complete the mandatory disclosure form on behalf of the seller, but it can be done.
So, Jan, I think finally on that one, I can say to you that if it looks like the roof is falling off, make haste slowly. Well, on that note, it is already 20 minutes after the hour. So I first of all want to thank our panelists. It was great having you with me on this show this morning. And then I want to say to our estate agents, principals, and everybody that's listening in this morning, there's one thing that I find that every new estate agent always aspire to be. They want to be different. They've got their competition out there and they say, what can I do to be different? Now, here's a perfect example. If you want to be different, because I think 80% of estate agents don't complete their documentation properly. So if you do it, you will be different in this industry. So hopefully you got a lot to think about this morning. And if you want to do anything good for your brand, go out there, get people to speak about the estate agents of a certain brand who are so good in completing their offers. Word by mouth is still very, very strong in our industry. Ladies and gentlemen, I thank you for your time, your effort, and our panelists once again. Many, many thanks. You are very, very busy people. Thank you for spending an hour and a half with our industry today. Thank you.
Thank you, Linda. Appreciate it.
Thank you, Nana.
Thanks, Johan. And
Everyone, thank you.
Thanks, Mario.
Bye.
Thank you.